Nora Devine, in addition to being an attorney with Stephen B. Perlman and Associates, is currently the chair of the State and Local Taxation Section Council for the ISBA. For 3 more days. So we're thankful that she's spending time with us during those last 3 days, because we know it's a whirlwind of activity there, and we appreciate that. She's very knowledgeable about the real estate tax assessment reduction process. That's what the firm does. That's what the Section Council focuses on. And she was the one who first alerted us to the problem that's going on here with the IDFPR's decision to single out certain attorneys for prosecution in this area. Craig Capilla used to be with the IDFPR, and he's currently with the Franklin Law Group. I heard his talk briefly on Thursday, and all I can say is, we've got 2 of the most knowledgeable people here today to talk about what the issues are. So without further ado, I'd like to ask Nora to step up.
Thanks, Ralph. Thanks, John. Thanks, everyone, for being here. So we have a situation in Illinois. We have a lot of property tax attorneys. They're usually centered in Cook County, but they do a lot of work inside of Cook and outside of Cook County. The first one that we have that has been singled out for prosecution is a guy named Terry Nader. He filed a residential assessment of complaint in McHenry County, specifically in Grafton Township. And he presented some sales and was asking the Board of Review to make an adjustment to the assessed value, which they did. Then he went further and he filed an appeal at the Illinois Property Tax Appeal Board, submitted the same sales, also made a uniformity argument. There are 2 principal arguments that property tax attorneys use when they're trying to advocate for their clients. The first is a market-based approach, where you're saying, no, my house actually isn't worth that. You have it assessed at, $100,000. I'm pretty sure I could only sell it for 80. That's a market value approach. That is what you'd submit your MLS sales, you'd submit an appraisal report, you might submit evidence of a recent sale. And in support of that argument, Terry Nader submitted MLS sales. And what happened so this is an example of the complaint. Most of us are still afraid to see the mailman coming at this point, because most of us are way out there with the same exact kind of evidence on the same exact kind of appeals that Terry Nader is being prosecuted for. Signed by Teresa Molina. Craig will talk about who the characters are in the IDFPR and explain a little more about how that process works after I wrap up my slides. And Patrick Bernard is the staff attorney whose name is on these complaints. So you'll notice here, this is the Property Tax Appeal Board complaint that was filed by Terry. And right here, the PTAB requires that you put a number right here. This number is a fraction of the market value. In Illinois, outside of Cook County, the assessed value, if all things are working correctly, should be 1/3 of what the actual fair market value of the property is. So if you're putting down an assessed value, you are putting down a market value too. So you are required to put this down, and if you send this form to PTAB without filling it in, they will actually send it back to you and they'll say you have to fill that in. So it's not like that we have a choice as advocates on behalf of our clients, like to just put in some evidence and not really draw a legal conclusion about what the evidence means, because they indeed require you to come up with a value here. This is the comparable sales. The PTAB wants to see this evidence in its own format so that they can quickly go through these appeals. So you do have to put all the data from the comparable sales that you're using here, and you'll notice that there's no place for adjustment. So these are unadjusted sales. So far so good, right? So this is where Terry Nader might have gotten into trouble. This is his legal brief that was submitted in support of his request for a reduction. And as I mentioned, he did also make an assessment uniformity claim, but that does not seem to be the basis for the prosecution against him. So here we have, in his brief, he has said, well, comp 1's a little nicer, comp 3's a little not so nice, comp 2 has a basement but no garage. I don't really know what it says, but it's saying stuff like that. So this is basically what the IDFPR is perhaps taking issue with, is that he's actually adjusting these sales and coming up with sort of a more precise value based on the MLS data. So the second, I'm going to pass this around. He gave us carte blanche permission to hand it out to anyone and everyone, but I still feel kind of wrong about handing out his work product and the complaint that was filed against him. So I'll pass out and just pass around and I'll collect it at the end. Okay, the second complaint that we're dealing with right now is against an attorney named David Bass. And can I just say, both of these attorneys are so nice. I mean, we're like, of all the property tax attorneys that somebody could have prosecuted, they really have picked the nicest, most mild-mannered people that they could have found in our profession. This is the complaint against him. This one came to me with the actual counts in it. There's not much to see other than, you know, there is a licensing statute right here cited, and it says in his brief, it amounts to an appraisal. So right here, said report contained an analysis of income approach and opinion of value for the subject property. And because he came up with an opinion of value for the subject property, which you have to do because the DuPage County Board of Review also requires you to put a number on the form. So, boom, unlicensed appraisal. Okay. So what did David Bass file? Well, I'll pass that around too. So this is kind of page 1 of his brief. And right here he's got what was the land, what was the building, here's the total. So this is the assessor's proposed number. And he's saying, you know what, based on this rent roll, based on the CoStar rental comps that I found in the marketplace, which he did attach, you'll see to his filing that there's a CoStar rental report attached. It didn't seem to me that he made any adjustments to the rental comps, but the issue with this filing really is that, you know, he kind of goes into, he presents the actual income statements, but he also gets a bunch of data off of the International Association of Assessing Officers website, which has a fantastic library. And mostly that organization serves assessing officials, but there are associate members such as myself, and we have full access to the library. And when I talked to David Bass, I said to him, I said, you know, some people saw your report and they said it looked, wow, way too much like an appraisal. Like, did you lift, you know, boilerplate from an appraisal? He said, no, absolutely not. I used the public resources available to me. I used the IRELA library. I used Realtor.com. I used all kinds of things to come up with an analysis regarding, for example, vacancy rate. For example, when you look at strip centers similar to the subject, what kind of expenses are they running? What are the typical expense ratios? What are the vacancy rates? And what kind of replacement reserves do you see with these properties? Then he gets into capitalization rate. He pulls some resources, does some research, comes up with some facts, and then he draws the legal conclusion that all of this adds up to a value more like this rather than what the assessor had. So there you go. He comes to a number, and that's allegation number 4 in the complaint. He came to a final, you know, specific number. So here he is summarizing his income approach. So he's got 3 years of data. Can't see it well, but it's coming around if you want to take a look at it. So it comes up with some kind of a stabilized operating statement that shows what he thinks the value should be based on the cap rate that he went with. So that's the situation. Craig here represents both Terry Nader and David Bass. He's going to talk to you about the status of the prosecutions. We got some news very, very recently about the department's response to Craig's motion to dismiss. So you're going to get some super fresh info this morning. And real quick, my slides include some reference to other IDFPR prosecutions. I did about an hour or 2 of research, and I came up with these sort of prosecutions that are tangentially related to the property assessment space. So it seems to me that the property tax appeal space has, for whatever reason, landed itself very heavily on the department's radar. So a lot of these are like cease and desist and like a fine. And I heard anecdotally that the fine is sometimes based on whatever the appraisal cost was. So whatever that person charged for that report, then the department's going to levy a fine commensurate with that. Unless you are very belligerent and you don't participate in the proceedings, then they can slap you with the statutory maximum, which is $25,000 per occurrence. So this one intrigues me. I want to FOIA all these, but I am afraid to because I don't want to get prosecuted next. But this one, she was a community association manager. So, I mean, somehow this woman landed on, she's a community association manager. I can only surmise what the facts of this case were, but it just sounds like, wow, this department has a lot of time on their hands. And the other thought that occurred to me was like, if we really want to get serious about prosecuting the unlicensed practice of law, we should perhaps turn over the regulation of the legal industry to these people. I'm kidding. And this guy, $750. Some of these people are appraisers in other jurisdictions, and they need to kiss the ring, pay the $150 for the provisional license. They need to get that temporary, one-off job license from the IDFPR before they're allowed to and woe to you if you don't do that, and we'll get to that on a future slide. Joe Thuvenal, this guy signed a lot of reports for a firm that does a lot of work in Cook County. They ventured out into DuPage County, and they found themselves turned in. And when the IDFPR kind of looked into their practices, they found that some of the people that were doing the heavy lifting on writing these reports actually weren't properly licensed because, little known fact, Illinois was an optional licensing state until 2009. It wasn't until 2009 that you actually had to have a license in order to be an appraiser or to call your work product an appraisal. So if you said you were an appraiser in 2008, you were. So a lot of this licensing and the teeth that were put into this legislation came about because of the financial meltdown, and they wanted to have more accountability. They felt that, rogue appraisers really had a lot to do with the real estate meltdown. These are interesting to me. Lee Noshafer, Chris Feniger, they worked for a company called Barron Corporate Tax Solutions. And Todd Barron was at the CBA last week for our presentation. And he, besides, lamenting the fact that they didn't hire Craig, he also mentioned that that it really just was, they felt totally railroaded. They entered a consent decree. These guys got fined quite a bit of money. And the circumstances surrounding this case was, this was two, I believe there were commercial properties in Milton Township, again, DuPage. So a lot of this stuff is coming out of DuPage. So someone in DuPage has figured out how to refer lots of things into the IDFPR and stir things up for various reasons that we can kind of only guess at right now. So these guys were not appraisers, they are tax reps. And I can come back and do a talk on the unlicensed practice of law in real estate tax appeals another time, but we could definitely fill 2-3 hours on that. So they're tax reps, and they go into the assessor, wheeling and dealing with their CoStar comps or whatever they have. And then when it comes time to go to the Board of Review, most of the boards of review do not allow them to file appeals. And DuPage is one of the counties that does. So DuPage allows tax reps to represent taxpayers, third parties at the Board of Review. So, but then when it gets to PTAB doesn't do that. PTAB will throw you out if you are not represented by an Illinois licensed attorney. And so these guys end up at PTAB with an attorney, a DuPage attorney. I think his name was Terry Benchoof. And so Terry's the advocate. These guys turn into the experts, even though they were the advocates at the assessor level and at the Board of Review. Now they're at PTAB. So now they've changed hats. They're no longer advocate. Now they're expert. But they don't have a license to be an appraiser. So they've labeled their report this is not an appraisal. This is a report. Not an appraisal report, just a report. And so I read the PTAB decision on both of these cases, and the PTAB administrative law judge basically said, so wait, you're not an appraiser? And they're like, well, no. And they're like, well, okay, I mean, and I think they were allowed to give some testimony, but at the end of the day, PTAB said, we're not going to give it any weight because, you know, I mean, you can imagine, I mean, it's a quasi-judicial administrative agency. Their proceedings are much more formal than the vast majority of the county boards of review. And, you know, the system is adversarial because you do have the taxpayer represented by counsel, not represented by a non-attorney, as is the case in other places. And then you do have the county either self-representing or represented by a state's attorney. So it is very adversarial sometimes at these hearings, and they have a very elaborate rules of procedure that really are similar to the civil procedures that we have in the courts. So, so they decided to not give it much weight because they weren't licensed. Someone sent in the transcript from the PTAB appeal. The consultant that I spoke to said that he just felt so strongly that it was someone in the Milton Township Assessor's Office. So these guys got prosecuted and fined quite a bit of money, $10,000 or $15,000 each, I think. So Joe Ryan, he's an appraiser that does a lot of work for property tax attorneys. I'm not sure if we use him much, but you know, it's customary practice for an appraiser to give you sort of a preliminary opinion of value before you have your client hire the appraiser. And you wouldn't keep your clients very long if you were having them spend $2,000 on an expert report that came in at a higher value than the assessor's value, right? So they have figured out how to do it, except for some of them have not figured out how to do it, and then they can get disciplined for, you know, violating the USPAP, which is the Uniform Standards of Appraisal Practice, basically. And that happened there. Then we have Bob Cruz, at the time, was the assistant deputy at the Cook County Assessor's Office. They went over his renewal application with a fine-tooth comb. They called into question and audited whether or not he had actually completed the CE that he had claimed on the form, and found that he had filled out the form incorrectly. And it was, you know, he felt that, well, off the record, he felt that maybe he got singled out or was, you know, given worse treatment because of his position in the assessor's office. So it was a permanent forfeiture of his license or something like that. Larry Starkman, I had a client who really, really wanted me to use Larry Starkman's reports. So I did, I guess, because nobody else would write appraisals on the properties that I needed to have written in certain counties because the values were low. And they were like, I was like, wow, I hope this settles, because I don't know if I'm going to be able to put this evidence on with a straight face. And the cases did settle, but then when I tried to call him a few years later to try to get new reports, he was just gone. I mean, the phone number didn't work, the email address didn't work, and then I was doing this research, and now I figured out why. Gary Fritz, he used to be a township assessor. A lot of these assessors also have like consulting practices on the side. They all do this. So they're not lawyers, they're not appraisers, but maybe one's an assessor in DuPage, and he'll let people hire him to go and try to wheel and deal out in Kane or Will or whatever. So you run into, you know, people kind of miss where the line is. This former township assessor, he's going out and talking to colleagues that he would have met through becoming, you know, known in the assessment world. And I guess he went a little too far and wrote something that looked too much like an appraisal. So you're unlicensed. Some of these people are clearly from another jurisdiction. On the next page. This is an interesting one to me. I've never looked at this one. I think that Craig knows about it if anyone wants to ask him. But I mean, this guy actually was telling people, I'm an appraiser. And Terry Nader didn't do that, and David Bass didn't do that. At no time did they say to anybody, I am an appraiser, this is an appraisal, you know? So I think the department really doesn't like it when you actually say you are an appraiser and you're not. This one was interesting too. Craig can talk about this a little more. She is a tax rep, so a non-attorney. I think she's a CPA. And she's also, maybe not a CPA, that might not be right, but she has the credentials to be a general real estate appraiser. So she is allowed to go out and value property any time she wants. But where she got into trouble was she was writing some values, submitting them to PTAB. She wasn't making them into full reports, which is a problem because USPAP requires that if you're going to write an appraisal, it has to meet certain criteria. So the problem she got into, I think, was that USPAP says you're not allowed to advocate for your value and you're not allowed to have a pecuniary interest in the outcome of, you know, what that value means to the person you wrote it for. So as soon as you say it's worth this, and then you go to PTAB and you're advocating for it and you're charging a fee, and I think that the record indicated that she did admit to the PTAB ALJ, like, yes, I have a financial interest in the outcome of this case. And it's like, okay, well, this isn't how the system is supposed to work. It works best when everybody's wearing the right hat. When you have an advocate, when you have an expert, and everyone's kind of, you know, to borrow Marty Paulson's term, swimming in their own lane.
Nora, before you go on, let me just ask a question, because I have this
Yep.
common problem of not seeing the forest for the trees. Of those folks there, how many are attorneys?
None.
Okay,
Yeah, I'm just trying to give you the broader landscape of, you know, the IDFPR being super interested in this like property tax appeal space.
thanks.
This guy was from Texas. I forgot what that one was about, but probably just from another jurisdiction, didn't get the provisional license. And this one was interesting because it looks like this was the IDFPR taking a shot at the accountants before they took a shot at the attorneys. One of the things that Craig said that struck me in a prior talk that he gave to the state and local taxation section council was, you know, that there's a sense in the IDFPR that the legal community is kind of like the third rail. And, you know, I think that I don't think we're gonna frustrate their expectations on that point. So KPMG, they were apparently using licensed appraisers who were full-time employees to value businesses, and some of the businesses had real estate holdings. So this got into, you know, KPMG LLP doesn't have an appraisal license itself, even though the employees of the LLP do have appraisal licenses. So I'd love to see the final decision, but basically they just decided to pay the money and hand over some kind of a policy related to how they're using these licensees. This one's interesting. George Lagassa from New Hampshire, he came in, and if I don't have these cases mixed up, I think I have it right, that he came in and appraised a nuclear power plant in Zion, Illinois, and I know the attorney who represented the taxpayer, and Lagassa was the expert that was hired by the representative for the taxing district. Because in larger property tax appeal issues, you do have what's called interveners, and they have a stake in the outcome of the tax appeal because their taxing district is going to lose revenue or have to refund money based on the outcome of the appeal. So the school district hired Lagassa. He didn't kiss the ring, pay the $150, get the provisional license. And I've asked Brian Weaver, the appraisal coordinator, I've asked him before, so how much would the license have cost? $150. And are these licenses freely granted? And he's like, yeah, basically. And I was like, okay, well, so is this not like a sort of a disproportionate kind of, you know, so we have sort of this pattern of sort of not much self-restraint going on in this division, in my opinion. So this one I love, Rick Robin, universally hated in all the land. I mean, he's been reported to the ARDC so many times. He's been reported to the IDFPR so many times. It's because of this man that the Lake County Board of Review changed their board rules and decided to disallow the practice of non-attorneys representing taxpayers, which was a great development, in my humble opinion. And everything's been going great since they did that. But this is somebody who he mass mails. I actually just got something from him. I'll pass this postcard around. I just got it yesterday. Okay, so he mass mails. He gets these people to sign up, and he, at the time, back in 2011, was telling people, I will craft my own, you know, value for you. Like it'll be like an appraisal, and I'll put it in, and the taxing officials will love it, and we'll get you great relief, and then you can pay me 50%, and which is high, by the way. I don't charge that if anyone needs help with their house or anything. And then everything will be great. So he got turned in by everybody, all different counties, all different levels of appeal, like private practitioners, appraisers, like, you know, assessing officials. Everybody under the sun was like sending this guy stuff everywhere. And he was like literally flipping people off in the hearing process. You know, I have it confirmed from a PTAB ALJ told me that he actually flipped her off in the middle of a hearing. And so the question is like, what are you doing here? You're not a lawyer. Why are you representing this taxpayer? And PTAB, to its credit, has done, better than most organizations in terms of holding the line against the UPL. And it does become the Wild West when you have unlicensed people representing the interests, the legal interests of people before a quasi-judicial administrative agency. There are a lot of legal rights at stake. I know I'm preaching to the choir, but so Rick Robin went, so the complaint was filed in 2011. It went through the process. It was a final decree, I think they call it. Craig can fill you in on the nomenclature, but it was handed down in like 2012, and I just passed it around. These are the findings of fact. They had them on these 3 properties here specifically. These are all growing out of Lake County, Illinois. And they basically said, this guy has no license, and he went ahead and developed these values on these properties. He's not an appraiser either, or an attorney. So, in the Robin case, this just goes to tell you, and Craig's going to talk more about this. It's kind of like they are their own judge, jury, and executioner. They decide whether or not their subpoenas are good, bad, or whether you can subpoena this or that. It's all just contained in this administrative agency, and you can't get to a judge until after the case is wrapped up. And even then, on administrative review, standards are hard to deal with. And Craig will talk a lot about that. So they call Brian Weaver, who is the appraisal coordinator for the IDFPR for the state of Illinois. And if any of you get his newsletter, you can kind of get a flavor for what you're dealing with. But he's he has a lot of strong opinions about who should be writing appraisals, and he is prone to write things in his newsletter like, they think we won't do anything? Okay, we'll pull their license. And he literally writes like that, so a lot, and you can read it yourself. And so, yep, he steps up. I'm an appraiser. Yep, that's an appraisal. And there we go. Rick Robin fined $10,000 for each of these infractions, so $30,000. So my section counsel has a member on it who works for the AG's office, and so somebody who used to work at the IDFPR, not Craig, but somebody else said, well, they don't really have an enforcement mechanism, so if they fine you, like nothing really happens. And our member who works for the AG's office was like, oh, no. Those are on my desk. I work on those myself, and people are paying those fines. So here's the part of the decision that discusses Brian Weaver's testimony. And he calls it a property tax appraisal. So words matter. We'll talk about the Zillow case in a second. These opinions were based on experience, education, he has no bachelor's degree, and review of the documents to a reasonable degree of professional certainty. So for everyone who doesn't know, or people who need a refresher, there is a Supreme Court case, in Ray Yamaguchi. This was an opinion that came down in 1987, and it stemmed from some conduct that was occurring at the Cook County Board of Appeals, and it's now called the Cook County Board of Review. Because if you just rename it, then you see it's all just different, and everything's above board after that. And I think that's why they changed the name. But I guess that there was a lot of, this attorney was signing a stack of complaints in blank. So he was just putting his signature on them, and they were blank, and he was handing them to a real estate broker. And he was saying, yeah, do whatever you want with them. And the real estate broker was filling out the complaint, pulling facts together, making legal conclusions, and he was actually attending the in-person hearing at the Cook County Board of Review, and he was stepping up to the bench and he was arguing before the quasi-judicial administrative agency about these people's property rights. That's what he's doing. So we have really strong language in Yamaguchi that says that even the act of filling out an appeal form is indeed the practice of law. And this case, and a long line of other cases, 100 years worth of cases, says that the Illinois Supreme Court has the exclusive right to regulate the conduct of attorneys. So, getting into the Appraisal Licensing Act of 2002, this is the citation. If you kind of want to see the context, I'll pass that out. So the penalty for unlicensed practice is up to $25,000 per infraction. So I was kind of thinking, like, PTAB has, who knows, Mauro, how many cases in the backlog right now? 45,000-ish? So 56,000, right. So a substantial portion of the PTAB backlog exhibits this kind of, work product on behalf of, attorneys like myself and like all the other property tax attorneys I know. So if you try to add up, what your exposure is here, it's daunting. So importantly, the legislative intent here basically says that it's all about protection of the public. And the department, importantly, did not allege any public harm in its complaint. So, I don't understand what the harm is in having an attorney step into the shoes of a property tax payer or a property owner and arguing their position on their behalf. So, Class A misdemeanor for a first offense and a Class 4 felony for any subsequent offenses. Woo! Importantly, there are some exceptions. So here are some people that cannot be prosecuted for unlicensed appraisal practice. It says assessor, various types of assessors, county supervisor of assessments, also called the chief county assessment officer, CCAO, and anybody that works for them. Interestingly, this subsection E does not carve out state's attorneys, who we deal with all the time on larger cases in Cook County. It doesn't carve out the PTAB board members or the PTAB ALJs. It also doesn't carve out any of the employees of the Cook County Board of Review. And on any day that there's commercial hearings, you will walk into the boardroom at the Cook County Board of Review, and there will be 7 or 8 on the left and 7 or 8 on the right, and every single one of them is looking at income statements and writing up income approaches and taking out a sheet of, cap rates by neighborhood and basically, doing an income approach on every single income producing property in Cook County. So if I were a commissioner of the Board of Review, I would want to change the statute to make sure that these analysts were covered. If I were, the chairman of the PTAB, nudge, nudge, Morrow, I would be wanting to cover my ALJs, right? To make sure that, because if you look at some of the PTAB decisions, they come up with their own approaches. Sometimes they're taking 2 appraisals and they're saying, well, we like this out of this appraisal and we like this out of the other appraisal, and therefore we're going to conclude the value more like this. I mean, how is the ALJ not engaged in the unlicensed practice of appraisal there? And why shouldn't they be covered by this carve out? And why shouldn't any licensed attorney advocating in the property tax system be covered in either this carve out or in some other subsection which we could add? And we could talk about the legislative environment in Springfield, but, lobbyists who really know things said, don't try this one right now. So it's not going to be like a legislative solution, at least not right now. Also exempt, real estate brokers. I happen to be a managing broker, so when I need to call Craig and cut him that retainer, I'm going to have him, make that extra defense for me. But she's a broker, It won't work, but at least I'll have that to argue about. Because it says basically you're only exempt from the Appraisal Licensing Act as a broker if you are doing a CMA, which is a competitive market analysis for a prospective client who's trying to list their house, or a BPO and maybe some other discrete things, but it's in the act that I just passed around. And then, interestingly, this automated valuation models, basically they're talking about things that are used by lending institutions. So you've probably all heard about this Zillow case. Barbara Anderson sued Zillow on an individual basis. She's an attorney. She's great. She's great to talk to. You should bring her to talk to you guys sometime. But she's a real estate lawyer, and she said, hey, I'm trying to sell my house. This Zillow value is really bogging me down because the people who are looking at my house are thinking that it's worth less than what's worth. And as an aside, I think Zillow relies too heavily on the assessment data that's public on the assessor's website. And sometimes that data can be pretty inaccurate depending on different things and where we are in the cycle and whether the market's going up or down and how fast. So basically, are we okay on time?
Oh, yeah.
Okay. And so the thing that they're saying is, oh, no, we don't have to have a license because we have this automated valuation model, which is specifically accepted in the statute. So the first thing I did when I heard about the Zillow case is I called Barbara Anderson. I got her on the phone and I told her about our woes. And I said, did you first go to the IDFPR and ask them to prosecute this? And she said, yes, I did. And I said, well, what happened? She says, well, they told me there's no violation and we're not going to do anything. And I said, well, did you persist? She says, yes, I did, because she's a very persistent woman. And I said, well, what happened then? She goes, well, I got a personal email response from Brian Weaver, the coordinator of appraisals. And he said to her, it's not an appraisal. They have all these disclaimers on their website saying it's not an appraisal. They have disclaimers. And then he quotes the disclaimers. And he's like, so therefore it's not. And she's like, huh, okay. And then she sued. And she shouldn't have to sue in her personal capacity. This is absolutely something that the IDFPR or the AG should be doing on her behalf, because there are a lot of people who don't want their property appraised on Zillow. And it's not an estimate, you see, it's a zestimate. So importantly, this is really important because Craig must have used this in his motion to dismiss on behalf of Nader and Bass, because I just got a peek at the department's brief in opposition to Craig's motion to dismiss, and I deduced that this was an argument that Craig made. A person, company, etc., is allowed to have an opinion of their own property. What a relief, right? But unfortunately, I don't know how a corporation articulates that value to anybody, let alone an assessing official. So you have a situation where they're allowed to have an opinion of value, they're just not allowed to use their counsel of choice to present that opinion of value to anybody else, apparently, which I think is sort of an unconscionable position for the IDFPR to be taking, given the fact that these lawyers are clearly trying to step into their client's shoes to advocate against, advocate on behalf of what the taxpayer's position is. So I'll take some questions and then I'll turn it over to Craig, and I might defer to him on some of your questions because it might be better off for him.
Marl, you're welcome to, jump in here anytime if you want to say something on behalf of PTAB. Okay.
What do you say?
I just want you to know, he wants to hear what the questions are. I just want you to know you have the floor anytime you want.
Yeah, anytime.
Well, if there are no questions, let me try to do something here. I want to talk for 3 or 4 minutes about my conversations with Craig Allison, and then Nora can respond and add whatever she wants. We can turn it over to Craig, but again, I have this problem with the forest for the trees because I'm talking to Craig Allison. We talked a couple of times, both shortly after the CBA meeting, and then again yesterday after he had met yesterday afternoon with Terry Murphy and Dan. Dan Coder's somebody else from the Coden, the president of CBA, sorry. And he gave me a very carefully crafted regulatory response about what their position is. But I had, some basic questions. I said, so how is the public harmed? I mean, I have this feeling that there's got to be some issue of public harm underlying the licensing requirement. And he acknowledged as how he's not sure that the public is harmed by any of these situations himself. He's not anxious to sign any $25,000 consent decrees against attorneys involved in supposedly the unlicensed practice of appraisal. But if attorneys are acting in a way that, goes beyond the bounds of what they're allowed to do and is verging into the appraisal area, He's agreeing that the IDFPR has to take steps and act in its regulatory capacity.
And he thinks they should draw that line.
And he thinks that they should draw that line, which is interesting too. And Craig is going to talk about the response, where there's a quote here. I'm just dying to read it, but I don't want to steal your thunder. You can talk about how he characterizes
I'll get there.
Yamaguchi and the IDFPR's position here. He told me he talked with Mr. Weaver, who heads up the appraisals. And he allowed us how they don't necessarily see eye to eye on every single issue. He will have further conversation with him. I talked about the fact that we have the situation where Weaver is the expert witness, and he just, kind of a slam dunk says, oh, this is an appraisal, boom, 25,000, whatever.
He's also a member of the board that votes on the outcome of the decisions.
Right. By the way, speaking
But
of
he
boards,
recuses when he testifies.
pull that microphone closer when you talk. By the way, I forgot to mention Nora's on the ISBA Board of Governors, so we thank her for her service on that. She may be a future president of the Illinois State Bar Association. He said he can't discuss the specifics of cases, which of course is very true. I'd like to think that he's trying to tell me that he's going to attempt to exercise some supervisory authority. And again, Craig Allison is the head of the real estate division. He oversees the work of all these operations, and he's the one who's going to be ultimately deciding whether or not anything sticks. Although he said in these two cases, he was unaware that they were proceeding. And he says if it's already at the ALJ, there's not much he can do. He's not sure. He's hoping that the ALJ sees the light and makes the right decision, in which case he can just kind of rubber stamp that. If not, he's not sure how he's going to proceed. He said he's going to talk to the general counsel for the ISBA and ask them to come up with a list of stuff that only appraisers can do, presumably to help define what the role is, and also presumably to define what the practice of law is. And Mike Rudy and others who've been in the background on this stuff since they had that legal services attempted change to the rule, it's, I'm sorry, just not the province of the IDFPR to determine the scope of what constitutes the practice of law. He surmises that there's a lot of activity going on with the various counties, and maybe there are some counties, I don't know, Grafton comes to mind, where maybe the assessor is an appraiser. Okay, please choose your partners and. Did we pay the fee for the use of the room or not? Sorry about the music, folks. Maybe Mark can see if he can work his magic out there. I talked about what constitutes an appraisal, and we talked about how generally it seems to me that if you label something an appraisal, you might run into some difficulty. And he agreed with the suggestion that, if nothing else, we want to educate members of our bar association who are active in this area that if there's a submission, appendix or something, or report they're going to submit, for God's sake, don't label it appraisal, because you're likely to, come under additional scrutiny. It's going to be an issue for you, and you've got people who don't necessarily know exactly where to draw the line between the practice of law and appraisals. We talked about the Zillow's estimate situation. We're going to be talking with the ARDC to talk about, what their view is of the IDFPR's foray into this area and whether or not they're comfortable with that. I specifically brought up the possibility of an exemption because we have in the statute certain exemptions. And I suggest, look at the MARS rule, the Mortgage Assistant Relief Act. He carved out an exception for attorneys within the scope of their practice. Why can't we have a similar exemption here for the traditional work done by attorneys and doing real estate assessment reduction work within the scope of their practice, not holding themselves out as appraisers? And again, the touchstone here, keep coming back to where is the harm to the public? And he allowed us how he really couldn't see in this type of situation any harm to the public. And so his general rule is he does not want to have something that's going to have a chilling effect on the activities of attorneys involved in normal, everyday tax assessment or reduction work, but he's leaving open the possibility that if somebody goes too far and actually uses the part of the brain that's not exactly legal analysis and puts on the appraiser part of the brain or something like that, that now they're going to run afoul of these licensing requirements. He also thinks that these organizations out there, the various assessor organizations and the townships, are irritated with attorneys for whatever reason. Maybe Rick Robin is having an effect, statewide, I don't know. But he thinks that a lot of these complaints are coming from those sources. He talked about the fact that banks use evaluations all the time. Why doesn't the IDFPR go after the banks? Why doesn't the IDFPR go after a lot of situations where people are providing opinions as to the value of some property? His view is that he'd like to get the word out on some broad line requirement here before any enforcement takes place. He would have preferred that this been published as, look out, don't do this kind of a thing to attorneys, and then let that sit for 6 months and then consider beginning enforcement. He says he wasn't aware of these two prosecutions, and he's not sure what's going on or why they came about. He did acknowledge that he wants input from our organization when they come up with this list of things that only appraisers can do, supposedly, and from the CBA, and from the ISBA, the Real Estate Law Section Council. So again, we're happy to be at the table and discussing these important issues. And I think it's pretty clear what my position is going to be. This could lead to a fight because, when we look at the Yamaguchi case, we look at the characterization and the response. I'm going to let Craig talk about it, but Lordy, it is eye-opening to the extent that they're suggesting that they are the proper arbiter of what constitutes the practice of law. And I just don't think that that's open to the IDFPR. I think that we are properly regulated by the ARDC. So enough about those conversations. We'll see how that plays out. And we have to have some response.
Yes, he reminded me, I had a couple more comments that I offered at the CBA that I forgot to offer to you all. I did have pretty frank conversations with 5 appraisers that I use very regularly in my work. Because they're genuinely obsessed with where this is coming from. Who is turning this stuff in? Is there some kind of a disgruntled undertone that I'm just totally missing? And there really is. The appraisers, like the assessors, also have this kind of side business where they do some tax repping and some consulting on the side. And one of the frustrations that I heard from one of my appraisers was, you know what? There used to be only a couple firms that were out here doing this work, and now there's 20, and I can't do this work anymore, and this is really frustrating to me. And I'm like, okay, that's not a good reason. I didn't say that, but I'm thinking, okay, there's a reason. And another reason that I heard was look, we give you guys 100 preliminary, not my firm, but other firms, because I like to think that we're fairly kind and compassionate to our experts, but they're you give us 100 preliminary opinion and value requests, and then you only order 30 reports, and then you treat us like you order a bazillion reports from us, and you really don't. And again, this is not pertaining to my firm, but this is pertaining to other firms. And then they said that they have some frustration about the fact that the advocate on a large case can make a substantial amount of money, and the appraiser is always limited to, their appraisal fee, which is on average $2,500 or maybe more if it's a really substantial property. They also said, so we have a bit of a turf war because some of them outside of Cook County have been doing this advocacy, and they don't like that attorneys have moved into that space to the extent that they have. New firms that they never had to compete against before, maybe my firm included. We, 7 or 8 years ago, we didn't have much of a Collier County practice. Now we have 600 files out there, so it definitely has grown. And so we have turf war, we have some professional jealousy, we have basically just protectionism, protecting the trade, because they would love to see this requirement that every advocate needs to hire an expert for every single tax appeal. And the appraisers want that because it creates business opportunities for them. And this was said out loud to me by my appraisers who like me and trust me, and I'm now telling you, so maybe they shouldn't have been so frank, but this is the vibe that I was getting. And then it's the assessing officials as well. The assessing officials want to see fewer appeals. So their job is to assess property, okay, and then the Board of Review, their job, they're statutorily mandated to provide an independent overview of the assessor's assessments. And when there is an appeal at the Board of Review, it creates work for the assessor's office. So the assessor's office, and in many cases, the boards of review themselves, want to see fewer filings because it would make their job easier. So this is one way that they can do that. They can push the needle in the direction of requiring every attorney to hire an appraiser for every single case. So will you have a reduction in appeals? Oh, I'm sure you would. I mean, there's no way you wouldn't, because not every case is big enough to justify the cost of an appraisal report. And not every client has the money to pay for an appraisal.
What's the average cost of appraisal? I'm sorry if I can.
For a house, it's between $450 and $750. And for a commercial property, it's hard to get anybody to do one with all 3 approaches to value for less than $2,000 on any property of any kind.
Okay.
So you're talking about a real hurdle to the review process if you start moving in that direction where everybody has to buy one of these. And that's all I had. Any questions before I turn over to Craig?
Before question, let me just say, we're going to talk with Craig about why this is important to our group, and what is the issue here. I mean, if I'm doing estate planning and I want to talk about a personal residency exemption on the sale of property or something in connection with estate planning towards the federal estate tax threshold, am I surmising, am I providing an opinion as to the value of the subject real estate that's involved here?
Well, and
Am I gonna
bankruptcy
run
and
afoul?
divorce and.
This thing has implications well beyond real estate practitioners. Any questions? All right, well, I'd like to introduce Craig now. Craig used to be with the IDFPR. Tell us a little bit about yourself and what you're doing, Craig.
Thank you. I will keep my comments regarding this particular case, or these two cases, necessarily brief. As was indicated, I do represent both of the attorneys that are currently under investigation and prosecution by the IDFPR. By way of background, I am a former IDFPR prosecutor working in the real estate division. Interestingly, the lead counsel on this case who's pursuing this matter is my former law clerk. So we certainly know all the players involved. I was at the department for about 4.5 years. I was actually a transactional attorney prior to going over there. North Shore residential and small commercial real estate. We had an office in Evanston. We were doing closings and closings and closings, and then we got to the fall of 2007, and I seem to recall that we did 3 closings in October of 2007, and it was time for me to find a new line of work. So I shopped around for a while, went over to the department. I arrived as a prosecutor at IDFPR the week before Bear Stearns collapsed. So if you want to talk about drinking from a fire hose, the mortgage fraud complaints, the valuation complaints were coming fast and furious at that point. We regulated all of the real estate professions. So that was real estate brokers, appraisers, auctioneers that had anything to do with land auction, home inspectors. They later carved out a special bill for community association managers. You saw one of them referred to in the disciplines earlier. And as this process goes, is a fantastically bureaucratic structure. So some of the players that are involved in this, all of this is being conducted right now at the Illinois Department of Financial and Professional Regulations Real Estate Division. That is this division that has the sole oversight of all of the real estate related professions. We've already heard mention today of Craig Allison, who is the director of that decision. He's the star on top of the tree. He's the final arbiter here. But from the ground up, you have an investigations staff, you have an administrative staff. Brian Weaver is the appraisal coordinator. He himself was a longtime appraiser. He started actually in the early 80s doing residential and commercial appraisers. He worked in the savings and loan market, did a lot of litigation work for divorce and estate work, and ultimately in 2007, almost exactly a decade ago, started his position as the appraisal coordinator for the state of Illinois. He is the board liaison between the state's real estate appraiser board and the department at large, meaning he is a member of that regulatory and disciplinary board. It is just phrased that he is a non-voting member, but he is present, has a seat on the board for all of these situations. You then have the enforcement staff. Those are the attorneys. You have 5 staff attorneys, which I'm jealous because at one point in time in 2009, you are currently looking at the entire enforcement staff in 2009. They have 5 attorneys plus a chief of prosecutions. That was the name that you saw Teresa Molina as chief of prosecutions, who signs out the complaints. All complaints under the real estate division umbrella come off of her desk with her signature. She reports directly to Craig Allison, the director. When a complaint goes through the process, a formal hearing, a trial is put on before an administrative law judge. The law judge writes up a findings of fact, conclusions of law, and a recommendation to the professional board. That packet goes to the full real estate appraiser board, which is staffed with a whole flock of appraisers and 2 non-appraisers. There is 1 banking member and 1 public member, who actually happens to be an attorney. They then review what the judge came up with, decide, do we agree that the judge was appropriate in determining the law, was appropriate in determining the facts, and what the judge says the outcome ought to be. If we agree, we rubber stamp it. If we disagree, we say, we think the judge is wrong and doesn't know how to apply the law correctly. Mind you, the judge is actually a lawyer, but that's okay. They then write their recommendation, a report on top of that, and all of this now gets sent to Craig Allison as the director to make a decision. So ultimately, he will be made aware of the existence of these complaints because he is actually the final decision maker, or in previous parlance in this country, he's the decider. All right, he has the final role to do this. Now, for both of the individuals in question here, it was a single count complaint. And Nora already referred to what that was. But the specific language was, for example, in the Nader complaint. In April of 2016, respondent provided a brief in support of appeal to the McHenry County Property Tax Appeal Board. Said report contained an analysis of comparable sales and an opinion of value. Said report constitutes the unlicensed practice of real estate appraisal. That's it. This is the complaint. That is the full length of the substantive material. I have it for you all on one page because that's all they wrote. Same thing for the Bass complaint. Subsequent to that, we filed a motion to dismiss the complaint on a variety of legal theories, one of which is that the department does not have the authority to regulate attorneys. Thought that was a pretty good starting point. We also advanced agency theory. As Nora had pointed out, there is a specific exemption under the Appraisal License Act that the property owner is exempt from needing an appraisal license to form an opinion of the value of their own property, of which individuals and corporations are permitted to do this. And as I said last time we were talking with any about this, for those of you that work in the property tax space at all, certainly if you're sitting in PTAB, I'm not exactly sure how a strip mall is supposed to tell you what it's worth, but apparently it is allowed to under the Act. Of course, everybody knows the requirements are, and it's not the same in every county. Some people will let some things slide, but by and large, corporate entities are required to be represented by counsel in legal proceedings. So there is an exemption here that says that the corporate entity may formulate its own opinion of value. But apparently the application of this is that the lawyer that they are required to engage just isn't allowed to talk about that opinion of value that the corporation has of its own property. So we advanced that. We advanced the agency theory argument as well. We further attacked the fact that the scope of that license act should be narrow and limited. The origination of appraisal licensing actually was born of the savings and loan scandal in the 80s. The first licensing programs for appraisers nationwide took off in 1991 and 1992. The state of Illinois had a voluntary program that if you were going to be engaged in residential real estate appraising for federally related transactions, meaning Fannie, Freddie, residential mortgage lending, you would be required to get an appraisal license from the state. Any other kind of appraising that you might want to engage in the original startup of this process was outside of the bounds of necessity of licensure, unless you invoked, well, I am an appraiser and the state said I am. Now, if you're saying that you are actually under the regulation of the state, you've called down the thunder on yourself. Beyond that, though, it was only narrowly tailored to be residential mortgage lending. In late 2009, they tightened up that requirement so that anyone with any sort of opinion of real estate value must be a licensed appraiser in order to promulgate that value in any sense or shape. We attacked that theory that this was never the intent, there is no public harm. The legislative intent of the License Act still refers to what's colloquially called FIREA. That is the original 1989 federal statute that brought it the origination of appraisal licensing nationwide. And finally, we also advanced a selective prosecutions argument that they've singled out these two attorneys and they're going after them. Well, there's a couple things now that have come out of that. As Ralph said, we did receive a response to our motion to dismiss that actually came in at 4:45 yesterday afternoon. So we weren't able to produce copies of that for anyone here today because we just got it and had to digest it myself. The Yamaguchi case came up earlier. And the Yamaguchi case is well-established law about property tax appeal being the practice of law and in the province of the Supreme Court. And again, long-established case law that only the Supreme Court has exclusive authority over the limitation of the practice of law. That is their province, theirs alone. Nobody else gets to put their hands all over it. The department has now argued back in their response to our motion to dismiss that Yamaguchi determined that certain aspects of the tax appeal process are considered to be the practice of law, specifically that completion and submission of appeal complaints, as well as appearance before the administrative tribunals. Noticeably absent, this is an I quote, I'm reading right from their brief right now, noticeably absent from that list of legal aspects of a tax appeal is the ability to determine the value of real estate property. Simply put, an attorney has every right to present evidence and advocate on behalf of their client, but that right does not extend to the creation of evidence by drifting into non-legal analysis that requires a different professional license. So I'm reading that to be the department taking a position that attorneys do not have the right to determine whether or not evidence is valid. You have to be a valuation expert under licensure to determine whether a value or evidence in support of a value is appropriate or not. The next subject heading for the next bit of the argument actually was the eye-opener. An agency relationship, so we're going to the agency theory argument that the attorney steps into the shoes of their client and is the voice of their client. An agency relationship does not allow respondent to act beyond the scope of his law license. So it again appears to me that IDFPR has decided to articulate what the scope of someone's law license is. And I think that is where we are going to have the argument to be made on this matter. Now, I was in Springfield about a week ago talking to a room full of appraisers. We actually, in our firm, we defend all sorts of licensed professionals here and in Wisconsin before all the licensing bodies there, at all levels of regulatory exposure. But we do a lot of real estate licensed professionals by way of our background, myself and Charlie Franklin, who's got his name on the door, has been doing this for about 35 years now. And that's actually how Charlie and I met as adversaries. But Brian Weaver was speaking before the Illinois Coalition of Appraisal Professionals in Springfield. They have a series of summer seminars. Fortunately, I've been honored to present to them for about the past 7-8 years. Brian Weaver is always on the docket. He's always the closer out of the bullpen at the end of the day when everybody wants to hit the highway and go home. And he comes through the list of here's all the things the state is doing now. And in front of a room of about 100 appraisers and a couple legislators down in Springfield a week ago, Brian Weaver got up to the podium and explained things that are currently going on within the department. And he referenced these two cases through a couple of the other consent orders from some of the disciplines you saw earlier, waved those out there, but made mention that they're not going in search of this stuff. Appraisers are not happy with this process, but more importantly, the assessors and PTAB are the ones that are sending this in because, I quote, they're sick and tired of this crap. We're sick and tired of the attorneys doing this stuff, and there's a whole lot of attorneys that are going to have to change the way they practice. And that is actually what he said to a room full of appraisers and a couple other lawyers in the room too. So as far as Brian Weaver has advanced, and I will say the department has a standing policy, they do not reveal the identity of the complaining parties. Interestingly, when a complaint comes in, the department assumes the shoes, steps into the shoes of the complainant and speaks and is the voice of the complainant. They assume that, but unfortunately, attorneys apparently aren't allowed to do that for their own clients. Be that as it may.
Can I just go back to that sentence? Because I'm still trying to digest that. I mean,
Yeah.
Every right to present evidence and advocate on behalf of the client, but that right does not extend to the creation of evidence by drifting into non-legal analysis that requires a different professional license. Now, again, I have this trouble seeing the forest for the trees, so let me just pause at this. I'm trying to understand this process. I don't do much of this work, but if I'm doing a real estate tax assessment reduction matter, and I'm looking at comps, and all the comps, you know, for 2 miles around my property show an assessment that's way lower than the subject property. And I opine on behalf of my client that maybe the assessment's a little high. Maybe the value should be lower. Have I committed the act of appraising without a license?
Based on what I am reading here, it seems that the department would define what you have done as appraising and not lawyering in that circumstance. And again, we talked about the pour-over of where this might impact other people, not just people in the tax assessment realm, but estate valuation, divorce matters. I gotta tell you, I defend a lot of appraisers at this point in a lot of places. In doing so, and that's in civil suits, that's in regulatory complaints, I opine as to whether or not the appraiser, or sometimes the expert in opposition, performed their responsibilities as an appraiser correctly. Appraisers are bound by the Uniform Standards of Professional Appraisal Practice. It's promulgated by the Appraisal Foundation out of Washington, D.C. They issue a new version every 2 years to update with ongoing trends to try to keep the profession in line. There is a section of those standards that dictates how an appraisal review must occur, what you must consider, how the appraisal goes. So if I'm in a courtroom arguing about the content of another appraiser's appraisal work, I'm afraid I have now stepped in it, because I am taking an opinion about the performance of an appraisal, which is also defined as appraisal work. So the far-reaching aspects of where this might go is really of great concern. They are supposed to be specific to real estate valuation, and that was what triggered the KPMG complaint. They had business valuation and going concerns, but some of the assets considered were real estate. So therefore, you must have licensed real estate appraisers only opining on the value, and they must be carved off from all of the other opinions of value of the other stuff. But here, I'm not sure yet where this stops, and I suppose that's what we're on the path to find out. That's about all I have here. Any questions from
We have an opportunity for questions. Let me bring this over to you because we're recording.
What does it take to get the appraisal license?
So there are a number of standards depending upon the layer of a credential you want. First thing that has to happen is you actually have to come in as an appraiser trainee. You have to come in as an apprentice. You get to do that. You must take 75 hours of additional coursework, and then you can pass an exam and you can get licensed as an appraiser trainee. Once you have your trainee's license, you can begin to work with other certified appraisers. The other two tracks are certified residential appraiser and certified general appraiser. Certified residential appraisers are only permitted by law to appraise up to a 4-unit residential property, and residential only, cannot be mixed use or anything like that. Must be residential only, up to 4 units. They are permitted to appraise those types of properties. A certified general appraiser can go out and appraise a bungalow this afternoon and an airport tomorrow and a rock quarry later in the week. They have full authority under their license to do whatever they want to do. Once you are a trainee, you can begin working on your experience hours, because to get certified in either direction, you have to take 200 additional hours of coursework to be residential, 300 additional hours to be certified general. You must then also perform 2,000 hours of actual real work product to be reviewed by the state board to be residential, 3,000 additional hours of work product to be certified by the state board again. And you have to have a certified appraiser signing off on your work as your supervisor while you are a trainee. So those are the two pathways you can follow. I mean, I hate to say it, one thing they have going for them, it is actually harder to become an appraiser these days than it is to become an attorney. And I feel comfortable saying that. It's almost as hard as becoming an airline pilot. It's really gotten stupid. But that is the field that they're in. If you are going to become a certified appraiser, you must also have a bachelor's degree.
Do you find it ironic that Brian Weaver does not have a bachelor's?
And so that was something that came out of the 2008 Appraiser Qualifications Board. Again, that's a sub-foundation in Washington, D.C. In 2008, they made a mandatory requirement that anybody going to be certified now must have a bachelor's degree. However, from the origination of licensing forward, that wasn't a requirement. So individuals who previously were licensed in whatever capacity were grandfathered through because you were already doing that. Much the same as at the dawn of licensing, the hours of experience, the testing, the coursework wasn't necessary. From the dawn of time in 1992, when Illinois started licensing appraisers, and right at that moment, for a brief window, you got to walk up, fill out your form, go, I are an appraiser, and they would hand you the license. Well, I guess you are. Here's your credential, and you can go from there. Each successive bad real estate market happening has led to additional ramped up requirements for these people to enter the profession, which is why we went from about 7,500 appraisers in 2006 and 2007 to about 4,200 appraisers in the state now. And if I remember right, there's less than 400 new trainees. The average age of the profession right now is 58, if I recall correctly, and nobody else is coming in because these people starting off as trainees, you're telling them you have to have, if you want to go forward anywhere, you have to have a bachelor's degree, you got to take hundreds of hours of coursework, you got to do thousands of hours of work, and for each one of these things you're going to do, we're going to pay you about $75 to $125. So good luck with that. Have fun paying your loans.
Other questions?
Do we have any idea, I know in my practice, both with doing this, with bankruptcy, with doing short sales, we use a lot of CMAs all the time. I mean, do we have any idea where that fine line is when a CMA starts to become an appraisal?
I think the department has an idea of where that line is. I'm not sure I
Or
can
a
articulate
BPO?
it. I do know of a circumstance right now.
It says specifically how you can use BPOs and CMAs.
Yeah, the statute does define how to appropriately apply a BPO, that you must be doing so under the cover of your real estate broker's license. I know of a pending case where an auctioneer who's licensed in both Missouri and Illinois came across the river and placed an opinion of value of sorts on a parcel of land for auction value, is also a real estate broker in the state of Illinois. So he was first charged with unlicensed appraisal practice, moved to dismiss, that was upheld, and then they subsequently filed a complaint that, okay, fine, well then you just did a bad BPO and we'll get you that way. So there's certain questions about collateral estoppel and res judicata hanging over that one, because it's the same agency, same attorney, same set of facts, and they lost one shot, so they're taking a different roundabout way of getting there, and we think there might be some process stopping. That one, we're not actually handling that one. Shane Banks has that one right now, but we're following that one fairly closely as well.
Vis-a-vis the BPO situation, it strikes me that if you've got an exemption for a broker acting under the scope of their license to do a BPO, there should be certainly a similar exemption for an attorney offering an opinion, like the situation where all the comps are way lower and you're just saying, I think maybe this is overassessed. You're not really going with a specific number, you're not doing specific appraisal work, you're just opining. Why wouldn't that be considered something that's permissible as the representation of your client under the scope of your license?
Well, it seems to me the natural line in the sand here is going to be the advocacy point. Appraisers are allowed to express an opinion of value, but they are expressly prohibited statutorily from being advocates. As an attorney, that is your duty. You actually are required to advocate for your client, which is what you're doing. Meaning the things that attorneys can do in articulating and arguing for these values can be done by no other than an attorney. I'm not sure how the department can then come out and say, yeah, but you're not actually allowed to talk about that. That's not your department. I'm missing the line in the sand on that one.
Well, let me just say we're going to be interested in participating in the process of determining where that line is, and I think you know where we stand on whether or not the IDFPR can define the practice of law.
Yeah, I'm just questioning, I mean, how is this not testifying for your client about your own opinion about the value of this property or parcel, wherever the case may be? I mean, that's where I'm kind of seeing,
Well, so the difference
or
is...
at least I'm not clear.
Right, and so procedurally, and actually this is something that probably Nora can speak to maybe a little bit better than me, but procedurally, an attorney isn't going to testify, now let me tell you, here's all the reasons why you have to believe in my value conclusion. But an attorney is going to step forward and go, see this sale, see that sale, see this other sale. That is readily available objective market data. It is publicly available. These are things that are known, that are recorded with the county or otherwise established in some way that is open information. You should be considering these things that the entire world is aware of and can see. That is not arguing for why my work is great. That is arguing for these are facts. I didn't make these facts, and I'm actually somewhat concerned that the department included in their line that the attorneys are effectively making or creating evidence. They're not. They're supplying evidence that's out in the wild already that is available to anybody who has whether it's an MLS subscription or the wherewithal to drive down to the recorder's office, which is a nightmare. I get that, but
Well, even the MLS didn't create that data. The market participants created those facts.
Yeah.
You know, so you're drawing legal conclusions from facts that were created by market participants and reported by services such as CoStar on the MLS.
so you're arguing a fact that is out there. You're not creating anything. The appraiser is supposed to be a property expert, and so they are creating their own expert opinion, which they can then state for a tribunal. But again, they can't do that unless I ask them a question about it. And then I turn and I argue their opinion. Now, I don't do tax appeal work, but I do enough litigation in the appraisal and real estate related fields that we get appraisers and their opinions of value all the time. The appraiser can only advocate for their own opinion of value, which they have to use objective, reasonable, commonly accepted methodology and data to arrive at. The attorneys here aren't doing that end, and they're not arguing for, hey, here's why my work is great. It's, this is the objective data, you should be relying on it. And I have no problem in that realm saying that is the province of an attorney.
Can I ask a question? It's for both Craig and Ralph. Does the IDFPR, I mean, are they being leveraged by a trade organization to be protectionist over their business opportunities? And if so, does the IDFPR understand that that's what's happening?
I will be brief in saying I don't know in so
I don't
much
know either.
as when I was in Springfield for this conference, I sat down with the leadership of the Illinois Coalition of Appraisal Professionals. That would be any communication, any directive to IDFPR from the appraisers is going to come from the board positions at ICAP. And they were actually all unaware of this pending litigation. So it doesn't sound like they were driving it. Now, if there are other appraisers just out in the industry that are pushing this, that may be the case. In fact, that may be very likely the case. If there is some sort of a political turn to any of these things, I don't know if any of you ever read anything like, I don't know, the Sun-Times, the Tribune, or Cranes. Apparently, property tax appeals are something we're going to be talking about maybe for the next year and a half. So if there is some undercurrent driving why this is an important issue, I can't say for sure. I don't know. I think everybody has some expectation of where this might be coming from, but there's no hard evidence on the surface that shows, yeah, here's one particular source or group that has an axe to grind that's driving this. That may become apparent over time, but I don't know that we have anything concrete at this point.
Let me ask Nora a question, or anybody else who does this kind of work. I think that the IDFPR's position, kind of is hinted at by Mr. Allison, is, hey, an appraisal for residential property is only $400 or $500. And if we're going to do this right and we're going to keep, things working the way they should, maybe we'll get to the point where we'll require an appraisal for every single residential real estate tax assessment matter. How would that affect your practice?
I think that's PTAB's department.
Well,
not
the
IDFPR's.
thing is, the boards of review, we have 102 counties in the state of Illinois, as most of you know, and each and every county has its own board of review. All of those boards of review have rulemaking authority. They are free to pass rules about what kind of evidence and what kind of testimony they will and won't allow. Most of the assessing officials that I work with, I teach for the Illinois Property Assessment Institute, which is the not-for-profit that conveys the designation that most assessors have in order to hold their jobs. And most of the people say, give me all the data. I don't care if you are an appraiser or not an appraiser, like I want to see all the data because my job is to get to the right number, get to a fair number, get to a number that won't be appealed to the PTAB, because once you get to PTAB, you're issuing refunds. And the school districts really don't like issuing these refunds. They like to have these things resolved at the assessor level or at the board of review. So in some jurisdictions, it's true, it's really true. I have to tell you, the situation is that the assessors are very cozy with the board of review members, and you cannot get relief at some of these boards of review. You cannot get an independent review of your client's assessment because of the relationships that are existing between the local township assessor and the board of review. And this is why we have the Property Tax Appeal Board, but both the board of review and the PTAB are both quasi-judicial administrative agencies. They have rulemaking authority. PTAB has to go through JCAR. Boards of review are just required by statute to publish reasonable rules And, you know, if they want to start restricting the kinds of evidence that they see, they may have some ability to do that. I mean, you're not allowed to, you know, bounce complaints as though they were never filed just because certain types of evidence were not submitted. But, you know, you can give things no weight and no change it. I mean, the Property Tax Appeal Board won't give any weight to any kind of an income approach that we'd submit without an appraisal. And they won't bounce your appeal as though it had never been filed. In other words, you still have administrative review of that final decision from the PTAB, but they won't give weight to that evidence. And everybody who does any kind of volume in my business knows that. So if you're going to PTAB, give them the evidence that they will give weight to, or don't bother, essentially. And boards of review could take a cue from the PTAB in that way. But referring people for prosecution is, I think, wrongheaded. And I think that it's designed to chill the property tax system in general, and so that fewer appeals are generated. And I think that it's not consumer friendly at all.
And before we wrap this up, I actually want to really quick bring Dan Haywood up here.
Dan?
Nora indicated that some of the activities that are going on at ISBA, which is her realm, at least for the next 3 days. That's still her chair.
Well, I'll still be on the Board of Governors another 2 years and
Yeah,
maybe longer.
it's the never-ending pathway
Yeah.
through that. So you've heard a little bit what ISBA has going on, and I will say that from the origination of this, the bar associations, ISBA and CBA, have been tremendously supportive of the attorneys in this matter. And I wanted to bring Dan up really quick because Dan actually sits as the chapter
I'm the,
chair,
the former
chapter
chair of the Real Estate Tax Committee at the Chicago Bar Association. My tenure just ended in June. It was like a 4.5-year commitment.
You guys are all getting out at the right time.
Yeah, but the executive director and president has asked me to stay on in my ex officio capacity to see this thing through to the end. So
Because 4.5 years just isn't enough.
yeah, and I don't have other things to do. But I just want to tell you what the CBA's position is real quickly here, but also highlight some points. Your question to Nora, she talked about the 102 counties, but in Cook County itself, there's 38 townships that open up on a rolling basis, 30 days, and you have a limited window to get evidence in. So logistically, in Cook County, I think it'd be impossible to get an appraisal for every single parcel. And not every parcel warrants an appraisal. There's a cost-benefit analysis that needs to be done to see if it's worth it to the client to get it. If you're going to require an appraisal on every single parcel in Cook County, you're going to see a really denigration of the quality of that work product. And I think you're probably going to see a widening of those appraisers that are going to get brought before this board for violations for not crossing their T's and dotting their I's. The other part, too, stepping back, is that since Illinois has been a state, the original Constitution of 1818 had a ad valorem property tax in it, which means at value. So you have to determine the value for the property to get to the percentage of tax that you're going to pay on it. And there's been different incarnations of that throughout Illinois statehood. Currently, we operate underneath the Illinois Property Tax Code, which charges the assessor with determining a value for your property, and then it also prescribes the recourse that citizens have under law to appeal that. So, you know, to me, it's an inane concept to just readily accept what the government tells you your property is worth. There's an access to justice issue here. Property rights in America are fundamental, and therefore they're given due process. So you should be allowed to present whatever evidence there is to say, this is why I think I should be paying tax at a different amount. So the reason I bring that up is because the essence of the practice is getting to a value. So you have to discuss value. There's no way to get around that. And that's what is being appealed to determine the assessment that your taxes will be paid on. So stepping back, the Chicago Bar Association, in my capacity as the chair, asked me to present to the Board of Managers on May 18th. So I went up before President Coton, their General Counsel Howard Suskin, Executive Director Terry Murphy, Chief Judge Tim Evans. A bunch of people sit on this Board of Managers. None of them practice in the property tax appeal area. So I had to break it down fundamentally to what it is, how it works, what the ramifications are for lawyers that practice in this area, but also what the ramifications are for lawyers in other practice areas if the IDFPR is successful in these complaints. I felt a little bit like Jeff Sessions or Jim Comey testifying before Congress, but it all went well. They unanimously voted to support our committee and support the lawyers that are currently up before the IDFPR. They passed a resolution authorizing kind of carte blanche action, and they issued a press release, and they had some materials that were shared in the Chicago Daily Law Bulletin. Yesterday, I turned in a draft of an amicus that they intend to use in this IDFPR matter. They're currently working on kind of like a diplomatic mission to reach out to the IDFPR. I think we kind of see where this is heading based on the discussion that Ralph provided earlier. They've also discussed a budget for potential litigation if we have to get into circuit court and intervene. The CBA approach is, in my opinion, very measured. Personally, I was advocating for them to get in there and start throwing some punches, but when you get a bunch of lawyers sitting around discussing what the best course of practice is, there's reasonable minds are going to differ. So that's where the CBA is standing on this issue. They're fully behind and in support of the members of the association and the members of the Real Estate Tax Committee, but they're taking kind of like a chess match approach to trying to resolve these issues.
Thank you, Dan. Let me just say on behalf of IRELA, we are concerned about the broader implications of this situation. If prosecuting lawyers can be viewed as a third rail situation, we're going to try to be a very active third rail. We'll work with Chicago Bar Association. We'll work with the ISBA. I know the Real Estate Law Section Council wants to take a position on this. There may be briefs that are filed on an amicus basis if an appeal takes place. We'll see what happens, but I'd like to frankly head it off before that. I'd like to make sure the ALJs are wise enough to render the proper decisions in these two cases.
Yeah, and I didn't mention before what the Illinois State Bar Association is doing, and I can't say much because the vast majority of these conversations have happened in executive session. So it's a secret, and I know the secret, and Anna knows the secret. But I can tell you that Dan just gave you some kind of a flavor for the CBA's appetite for a direct conflict over this issue, and I can tell you the ISBA's appetite is higher.
We don't have any more time. I wish we did. This has been an instructive, enlightening discussion. I want to thank Nora and Craig and Dan for taking time out of their busy day to come. Let's give them a hand.